Hello, good evening. Welcome to the Parent Advocate Network, brought to you by the Coalition for Protection of Children and Families. I want to welcome everyone here tonight, and we are going to be talking about a few different issues, a lot about connecting state by state and advocacy, and how parents can advocate for each other. And if you want to know more information and how to get your children back and how to protect your rights as a parent in America, you can go to our website at coalitionforprotection.com. And there's a lot of information here. We have all of the states across this country listed, and you can click on any of these states and it will take you, like for Illinois, it's going to take me to a page about Illinois, and it talks about rights in the state as parents go, and then it also talks about national laws that all states are supposed to be adhering to. And what we're coming up with right now is that a lot of states are ignoring the Constitution and constitutional rights of parents and children all over the nation. And this is not just a national issue, this is a global issue, but we here in America are focusing on the American children wrongfully taken from their parents, and how we can bring them back and stop these senseless acts of inhumane treatment against children and parents and families. And so with that, I wanted to open up with a prayer here that we do at the beginning of our meetings. And it is brought to you by Earth Soul Ministries, the Law of One. We are all one. And when
we are all one.
And when one is there, thank you. And when one is harmed, all are harmed.
When one is harmed, all are harmed.
And when one is helped, all are helped.
When one is helped, all are helped.
And when one is healed, all are healed.
When one is healed, all are healed.
Therefore, in the name of who I am.
Therefore, in the name of who I am.
And I am one with all that is.
And I am one with all that is.
I ask that only that.
I ask that only that.
Which is in the highest good of all concerned. Happen.
Which is in the highest good of all concerned happen.
And I give thanks that this is done.
And I give thanks that this is done.
So be it, and so it is.
So be it, and so it is. Amen.
Amen. And we have Fernando joining us tonight, and I'm glad you were able to join tonight. And we have Dale as well, and we're just starting off this meeting. Fernando, was there something that you would like to share tonight?
No, well, pretty much, yeah. Pretty much I help parents out with their federal matters and trying to get them the proper information for the federal court system and how to bring their case about, and those deprivation of the rights and constitutional right violations. So I just want to put that out there so that way people know who I actually am. I mean, a lot of people know me, and I'm very well known throughout this movement for helping those people. I mean, I've gotten other kids back with their actual families. I've had testimonies as to that. And I mean, it's every moment that goes by that they're suffering, it's saddening. When there's a moment when it comes to reuniting with their families, it's exciting, you know? And so I look forward to the next child that comes back to, you know, be with their family rather than just, you know, be left for adoption and forced out adoptions and then left with a stranger. So
thank you very much for all you're doing there, Fernando.
Yeah, it's a lot of work, a lot of reading, mostly in the area of the state statutes and the federal statutes and the federal law and the constitutional law. So, I mean, the civil law, the civil rights law, it's just saddening that, it's not adhered or recognized by the state. But although there is state statutes, and it's absurd how they have these things in place, but they ignore them. And it should be strict scrutiny when it comes to, anyone's parental rights, but yet the state doesn't recognize it.
And in some states, such as California, the state doesn't even recognize parental rights as fundamental rights in any way, shape, or form.
They don't.
They consider our children not our children, but this children's of the state, right?
Yeah, well, pretty much at birth, you're given a legal name, and that legal name then carries down some contract with the state. And I mean, it comes with any property. I mean, you're left to have to go to the state to get either a license or a permit, or, a certificate, or, registration of some sort, so it's just, I mean, it's extortion 100%. But then where is the federal law in all this? It should be that the federal law takes precedence and prevents all this.
Yes.
But it doesn't.
No, it doesn't. I've heard a lot of people expressing concern about going to the federal government, feeling that the Supreme Court is not going to listen to their complaints because they have not been very pro-families in the recent decades. And what with the change of all the new Supreme Court justices, it's even more scary.
Well, there actually is over 80 years of case precedent when it comes to the, I think it was Troxel versus Granville.
Right.
And that way, that gave the care, custody, and control to the parent, and the decision making to the parent, as long as the parent was fit. And the standard is supposed to be, clear and convincing evidence, but they don't use clear and convincing. They use a reasonable cause or prima facie evidence to effect these constitutional rights violations, and they use a civil system instead of a criminal system that's supposed to be in place in times when there's crimes. They don't use it in appropriate manners, and they don't use the standards to those case precedents. But I feel that if they go to the federal court, they're going to get more less bias, and they're more likely to get justice, only if they can come up with a comprehensible cause of action. When they don't form causation and they make a complaint and it's a story, most of the federal judges, I was told by attorneys, that they only want to hear the facts. They only want to see whether or not there is causation. If there's causation, then they're going to care about whether or not the case goes forward, because the criteria in the cause of action would substantiate the claims and the deficiencies for the lack of violations, which is the cause of the cause in the action. So, I mean,
Fernando,
a lot of these parents don't do that.
Can I hold you right there? Because now, so you have an example of someone's children taken away from them, and the act of you getting their custody of their children back. So could you just walk us through the procedure that you went through to do that on the federal level over and above the state and county and city?
Well, on the federal level, no. On the state level, yes. I've dealt directly with the parent and mitigating their circumstances so much that the case doesn't even have any. There's no reason for the case any longer, and it gets dismissed, and they actually get their children back because of that. And that's actually at the lower level that I've helped. And
So
the
now,
federal level,
that case right there, that was the most egregious and that the court responded to. Could you just kind of give us a napkin sketch of what the facts were and how they got possession of their kids?
Well, the parent, I gave him a document. I made up a legal document for a lot of parents. It was around that same time when I made this document. I sent it out to this one mom. This one mom was in my group. It was called. It's still on Facebook, but I don't have access to it, and I needed to make new groups
Oh,
because I don't have access to that group. So pretty much the advocates helping parents find their local federal courts. She put a testimony up on there saying that, when I produced this document and I gave it to the authorities, the local authorities, they actually felt that that document take precedent and they just dismissed the case entirely. It was as if they didn't even have any reasons for the case any longer, and the case just diminished. And it was because the parent gave judicial notice to the judge and gave everyone else in the courtroom that document.
and this was while that parent still had some parental rights, correct?
Yes, they were going forth with the termination, and she was fearing that she was going to have a termination of parental rights later on, but it wasn't there yet, and it was before the 6-month review when she produced the document. There's been another mom. She was an Indian mom, and she's in Shasta County. She was a parent I helped, one of the first parents I've helped, and she got her Indian children back because I pointed out the Indian standards, according to what California's standard is on that. And it's federal, but California implements that in the courtroom. Not all the time do they listen. In Shasta County, it was horrible because they weren't listening at all. And no one was objecting. No one was bringing up issues. This mom pretty much brought up the issues the way it was, told them about the deprivations that they were doing and the standards that they had to use that they weren't using. And she got her kids back just because she had the correct material. I fear that when parents get all this information off the internet and they don't have the correct information and they use it, that it just throws off their case. They get in a deeper hole. They don't know what they're doing. But when someone can go and say, here's the law, read this, this is where it's at, and show them, and then, comprehensively tell them a process that's going to work. And then they go and implement this process. I've understood that in the state court and in federal court, mitigation of the circumstances is a big, big key in winning your case. If you can't mitigate your circumstances, then you're not going to you're going to have all these injuries and all these things happening to you that you're not going to be able to put a stop to.
And they would not consider.
Could you elaborate? I was going to say, could you elaborate on mitigation?
Okay, mitigating would be, okay, so that their procedure is something, and you're going to come up and bring into that something that is going to be concrete, like information that needs to be exposed that they're not talking about. Maybe the social worker is talking about all the other things that are happening and keeping all the information, like visits, your classes that you're doing, reunification services, things that they're doing that is in the parent's favor that's just not getting heard in court. That there is a way to bring that about, and whether that if you bring it about to court and they don't want to have it, they're not going to hear it, they reject it every time you're trying to bring it about, you got to file it in an appropriate way, the way that the court rules specify that filing's supposed to be filed. And then once that happens, it's going to get a court date. Everything that's filed then becomes court record, but it then has to have a hearing. And that hearing has to give a certain standard of how much am I going to be heard? How much standing do I actually have when it comes to the criteria that I'm presenting? And when it comes to the social worker is only trying to, use the process to affect the constitutional right deprivation and deprive the parent of their constitutional right, which we already know is equal to the child. The child has the same constitutional right under that case
Right.
that the parent does.
Hi, Kelly. I know you joined in late, and I want to welcome you on. I hope you're understanding what Fernando is talking about. And I was also going to ask, as far as mitigation of circumstances, would it be fair to assume that that would include mitigation of whatever concerns or fears may have been risen in court by the Department of Children and Families by providing proof evidence of difference of opinion, like in a psych eval or in other
Well, like say in the cycle
education?
evaluation. Okay, so I'll give you an example. So say you go and they want you to do the cycle evaluation, but if you go to do this evaluation, you know that the evidence is going to be used against you because they contract with the child protective services.
Right.
So that's not in your favor. They're not going to get paid if they're not going to give a favorable decision to child protective services. So in your case, your mitigation tactic would be to do everything in your power to know that it's a civil court order. Disobedience to that order is going to be in your favor, rather than going and submitting to that order.
Not necessarily.
It's going to be bad for you because you're going to.
Not necessarily.
Sorry. Hold on. I messed up. Let me fix that. I apologize. Okay. Sorry, Fernando. I cut you off there. I apologize.
Well, they're getting paid by someone. What makes you think that someone's going to pay them if they don't give a favorable decision? The favorable decision is that the parent is unfit. So therefore, now I got the unfitness. I can now proceed to deprive the parent of their constitutional right. No, so if that's not favorable, then they're not going to get paid, and they're not going to have an unfit parent. So that's the reason why I say that. But when it comes to mitigation, that's the topic. Let's not veer away from that, and getting caught up in the other circumstance. The circumstance is mitigation. So unless there is an actual medical professional present in court to present the report, it cannot be a social worker presenting the report. The social worker is not a doctor. They're not under the state medical board to give a diagnosis. You cannot have a third opinion from a social worker after a report has been made by a professional. So that's another thing. Oh, they're going to try to admit this into evidence. It does not uphold to the standard of evidence. Rules and evidence is under the court rules of evidence. That determines whether or not the evidence that is presented before court is going to get admitted or not admitted. So that's a big thing right there, is that if you know what's being presented is not being presented by a medical professional, yes, it's signed, but is that medical professional there? If he's not there, the social worker can't talk on behalf of the medical professional without making that violation, and them themselves could be reported for trying to give a medical opinion as a professional, acting as a professional in that capacity when they don't have any credentials as to that.
Right. Kelly, you had a question there. Wait,
Lyra,
Gail.
I was gonna say something here, Fernando. Now, in Kelly's case, it was suggested that we get an independent psych evaluation from another party, and if the evaluation from that psych evaluation was contrary to what the court's opinion was, that we have a finding from a professional that says she's more than qualified to take care of her child, and it conflicts with the court evidence that they're basing their separation on. How do we mitigate the evidence?
Okay. You have a right to not have to go to theirs. You can go seek your own. And that's what I suggest, is you seek your own.
Now, this is really critical, Kelly. When Scott says what we need to do is get an independent psych evaluation. Here's Fernando, who's been successful in reuniting families, and that's what he's suggesting.
I understand. I understand, but okay, yes, I can get another psych eval.
Okay, now listen.
Dale,
on.
Dale,
Just
will you
a
please
little-
let Kelly speak now? Thank you. Kelly?
Okay, I can get another psych val, but by someone else. But I have done psych vals from CPS psych vals, but they were not in my favor, which I thought they would be, but
Now, Fernando, this is why I say listen to what Fernando's saying.
I understand. I know what he's saying. I know what he's saying.
Well, he's saying that the psych evaluations that are conducted by the people that they send you to have to give a negative.
Okay, I understand, but you have to have money to find your own psych val first.
Okay, well, as advocates, Kelly, if we can find an independent professional to give you a psych evaluation and to give it, forget about you coming up with money. I didn't say anything about money.
But you have to have some money.
Okay, well, the point of it is
there's always someone we can find. So there's always someone you can find.
Yeah.
Okay.
Scott is started to have communication with the disability department there, Missouri, and so he's starting to get some response from them, and we might be able to find somebody to give you an independent psych eval that you don't have to pay anything ever. Don't worry about it. It's a part of the process of what we're looking into, the avenues that are out there.
They're talking about psych vals. Psych vals. You know what I'm talking about? Okay, it's like, okay, you know how I did a psychic val
psychic val.
Yeah, that's what they're talking about.
Well, this is just one of the things. Fernando has a lot of information that he's here to share tonight. But one of the things is that, those psych evals that are done by CPS are rigged, and they're always going to vote or write a report in favor of the department because they get paid by the department to do the evaluation, and it's in their best interest. And psychiatrists get
I have one other thing, too.
$2,500 per evaluation. Go ahead, Fernando.
Most of these professionals that are in cahoots with Child Protective Services have worked for counties before, and it may not be the circumstances in all of them, but there is some who those circumstances do apply. Like the professional is in cahoots with personally with people in Child Protective Services or judges or attorneys in that process. They've been involved in other parts of the process and then are acting in these other capacities. Some of these people in Child Protective Services have been so scandalous to act as a professional that they're not even qualified to act as. And so it's just disturbing because when you ask a professional what their, occupation is and who are they acting as, what's the badge saying right now, when they're talking to you, because they come trying to talk to you in so many different ways that you just don't know whether or not, that person may be having the same, two different job descriptions and it looks like they're doing one job. So there's a lot of different scenarios in this, where attorneys then, have interpersonal relationships with the judges. It's like or law enforcement. It gets really bad.
Even
let's just say, let's carry the case further. So we've taken Kelly down to the psych evaluation. We've got the document, and now where do we go with that document to present the evidence in her case, typically?
Well, Child Protective Services has a stamp at their counter. Anytime there's in the law, it says you can self-authenticate a document. Well, this purpose would be that you would go get the actual document from the evaluation and have proof of it, right? And it's signed and everything. Well, then you go self-authenticate it with, Child Protective Services, give them a copy of that. You want a copy of the one that was self-authenticated, that you have the actual original. You can present the original in court to say that they actually received that document. That this is we went to go with the letter, accompanying obviously with the letter describing what you guys did is seek an independent psycho evaluation. This is the results, and that you guys are, don't think the results that came from the other opinion are correct, that these are the recent results.
Well, the psycho evaluation, when I read it, okay, when I went to got my master's degree, and I had classes in analyzing testing, and one of the things I noticed that, number one, she had misinformation that she got from DFS. Number two is most of what she said about Kelly was opinions of hers with no backup by any document.
No medical means.
No.
Just opinion.
Just opinion, and she tested her on learning disabilities, and she came up with her having a 6th grade level. But the thing of it is, Kelly has 3 learning disabilities. One is because of her eyes, which her right eye muscle was damaged when she was about 3, and therefore she cannot track with her both eyes. With her right eye, she cannot track at all. She leads with her left eye, and she cannot converge on the same point. And when she sees writing, she may see it up and down. She may skip lines. She may see double vision. And they did not, and the memory and the aphasia is she sometimes cannot get out the words she wants to say. She knows what she wants to say, but her words won't come out. On all of these, dyslexia, and all of these are not intellectually, they don't affect the intellect. They affect the way she learns. But these 2 doctors, the neuropsychological doctor and the psychologist, neither one of them gave her any accommodations for having these problems.
And they don't make any differentiations, like they don't make any distinctions between the two. They don't even recognize it. They just give their opinion, right?
Right. And then this is what's troubling is, okay, when the judge decided on Kelly's termination of parental rights, that was his lead decision. Part of his decision was that these, according to the testing of these 2 doctors, in quotes, that she had a mental illness which was not able to be taken care of in the immediate future. So therefore, she would not be able to take care of Michael. That's what he let in with.
But the
That in itself doesn't give enough criteria to, remove the rights from the parent in a TPR proceeding, because it's the standard is the opinion, and they didn't use no medical background in regards to the opinion.
Okay, the reason why they took Michael from me was, first of all, Michael had failure to thrive. Is that it?
Oh, Michael had failure to thrive, but the main thing is, and I have documentation from that. It's my nephew was our lawyer the first time around, and
failure to thrive.
what my son Michael was having failure to thrive back in after he was first born, which was August
the 23rd,
2013. Yeah, 2013.
Was that a CPS doctor or was that an actual doctor?
That was the actual doctor.
It was the what do you call it? Pediatrician
doctor
described it, and in his notes, 9 different times he points out that Michael had failure to thrive, but he was well fed, he was well nourished, and he was hydrated.
Yes.
But that's not what DFS is saying. But the DFS setup comes from Children's Mercy Hospital. Children's Mercy Hospital is the one that influenced DFS to say the things they're saying, because in their report several different times they accused Kelly of not being able to take care of Michael because of her cognitive ability, and they actually said that both Kelly and I were learning challenged, and we weren't capable of taking care of Michael.
So at this point, Fernando, they're at the state appellate level, and their attorney is not coming to defend these civil rights violations, ADA violations that are present in their case. And so what do you think they should be doing at this point?
Well, the civil rights. Okay.
Well, that's the thing, at the state level, it's kind of hard to get what you want, because of the officials all in cahoots with each other. I mean, there's delegated authorities and all these, because of that, someone has to answer to someone. And all of that creates a, telephone type situation where, things are said and created to be, it's almost as if, when you go in a courtroom and there's a jury, but instead the jury's CPS. And instead you got, the court being the jury, and you don't got no jury, you just got a whole bunch of telephone conversations going through different officials. These officials now form opinions. Those opinions lead to the parents having deprivations of those constitutional rights and protections. Equal protections under the law, under the 14th Amendment, are supposed to extend to everyone, regardless of what, if there's a law that abridges those rights or privileges or immunities, that law is not constitutional. It's supposed to be that way, but they don't use it that way. They use these state statutes over the federal statute or federal law and over the constitutional law to perfect these things against parents. I don't think they can use this process, the juvenile dependency process, for this the way that they're using it. They can't deprive a constitutional right that a parent has or a child has with each other and determine that over a federal court. I mean, there's 80 years of federal court precedent when it comes to this. And the standard for removal is that the evidence that needs to be provided to determine whether a parent's unfit or not is the clear and convincing evidence. It was ruled by a federal court. If there's a civil rights case that you bring about in a federal matter, you may have more access to, better justice. You may have justice.
Well, in the process, there's one question I wanted to ask Marge and Kelly. Has your appeal on the state level been denied yet?
Yes, it has. In fact, we appealed to have it heard again, and they denied that.
Okay. Now having said that, Fernando, if we get a copy of the pediatrician's evaluation that Kelly's more than capable, the baby was and healthy and thriving, and we get a psych evaluation from an independent that conflicts with the state evidence, how do we proceed now as far as going on to the federal appellate level?
There's different criteria in the federal law than there is in the state law. I would actually ask the person you're getting the evaluation from when they make their letter or whatever, that it complies or adheres to those standards and when making that document.
Are you saying it complies to the state standards?
Well, federal, I mean, there's state and federal, because if you're going to present it to federal court, the state color of law is not going to work. It's not going to be recognized in federal court, and any state statute doesn't get recognized. When it comes to the state statute, that's dictates how the document is made. And so when you have federal standards that need to be met, I know what those hospitals know what they are. Healthcare law is federal. I would think that they could make a letter that would come up to those standards, you know?
And well, the question being, you bring back the issue of the state court. Now they've been denied appeal on the state level.
But it's on the state appellate court, which is different from the state Supreme Court, right, Fernando?
The appellate court gets their authority from the Supreme Court, and that's how it works. I don't think that the appellate court process is any different than the lower process, because what happens, and it's happening in your guys' case, the attorneys get threatened, or the state comes after the attorneys if they help. They don't want to help. They don't try to help. They just, they'll act like they're helping, and then there will come a time where they're supposed to be doing something and they're not doing what they're supposed to be doing. And that happens all too, often. And there's a right to an appeal, and you have a right to appeal any matter, but they don't give you the right.
Now, so do we go over the appellate court and appeal on the state Supreme Court level?
It would be a petition for review to the Supreme Court.
Yeah, I've done one of those. I remember that when I sent to you, you were talking about having read it just recently.
Yeah.
And so that's
where I got that you have a right to an appeal. It is a right that you have to appeal. I mean, any judgment that's final.
Okay, my statement is we did appeal it, but they denied it. But my attorney is trying to get the appeals judges. They want to transfer over to the Missouri Supreme Court. That's what we're trying to do, and that's where we are at right now.
Okay. So, the other thing is that she did appeal, and she did bring up Kelly's civil rights, and they turned it down anyway. She also asked them to consider sending it to the Supreme Court as an option. They turned that down. So basically, they just didn't want to cooperate.
Exactly.
Well, and this again, Fernando, this has to do with
the way that the states are in this is the states won't get paid unless the county affects the things that they're doing.
I know, and I know everything is wrong. Everything, I know they get paid, but that's wrong. And I know they stole my son. They stole a lot of people's kids.
They kidnapped. That's what they did. They kidnapped.
I know that. But we are trying. All of us are trying to turn this whole thing around, trying to get our kids back. Which that's what we are trying to do. Some of you people already got their kids back, which I'm so happy and I'm so glad. But I'm trying to figure out, okay, when is it my turn? When is it Lyra's turn? When is other people's turn?
Well, Fernando, it has to do with exhausting all remedies and presenting evidence to the on the Supreme Court level that is going to, there are mitigating circumstances. Is that independent psych evaluation and the original evaluation by the pediatrician mitigating?
Not at the Supreme Court level. No new evidence can be entered. Only in the appeal it could be entered too. But that's if the appeal wasn't denied. And the Supreme Court's only going to review what heard in the appellate court. What you need to do is that independent psychological eval, because not only will it give new evidence under the state law, new evidence in a federal court, when you do bring those constitutional rights violations, you'll be able to say, well, I have an actual independent psychological evaluation that says this, and I don't think that the opinion from CPS's psychological eval is correct. I mean, I got a second opinion. This is what the second opinion is. It's more recent.
Yeah, well, I'm trying to build a case here and get to the point where an independent psych evaluation is essential and necessary to proceed with a federal appeal with a state Supreme Court appeal.
Okay, what the question is on that is, okay, she had one.
No on the Supreme Court, but yes at the federal case level.
She had one psychological evaluation and one neuropsychological evaluation.
Exactly.
So where do we go with that?
Okay, but the neuro, I think it's the neuro,
Yeah.
And Mary Richardson.
No, that's
Is that the second?
Mary Richardson is a psychological.
Okay, but she said that after I did her test, she
The neurologist is not going to really matter in that. It's going to be more the appendix.
Oh my gosh. Okay. Never mind.
Okay.
Okay, I was just trying to say, and all of a sudden I get like a little bit, somebody this disrupts me. I was like, okay, fine.
All right. Yeah.
Okay. I was trying to say that Mary Richards, whoever, I forgot where her name is. She the psychic?
She's a psychologist.
Okay, the psychologist. She, in her report, she said that she wants me and Michael together. That's what she put in her report. She was for reunification. But when my caseworker and everybody else got the reports, everything changed. Like my caseworker didn't believe me. She read the psychological evaluation paper. She still didn't believe it. It's like, okay, it's in that paper, no matter what. It's like, okay.
So they only highlighted the particular information that would support their claim that you cannot take care of your son, and they omitted the rest of that report. And what Fernando was trying to explain here is that that's the third-party opinion and should not be admissible in court. Correct, Fernando?
Yeah, it's hearsay. It's an out-of-court statement made by third party.
That's what I was trying to do.
You should join in.
All right, so Fernando's trying to answer you here, and if you can.
No, it's
all right. Shall I mute? I mean, let's let Fernando complete what he was trying to explain here.
So the part of the rules of evidence in every state, it don't matter whether that's state or federal, the same rules apply. It's hearsay. When hearsay is brought about, the definition in law, the legal definition is an out-of-court statement made by a party other than the person that has firsthand knowledge of the statement. So if they don't have firsthand knowledge of the statement and the statement was made outside of the court, It cannot be used in the court as evidence. And that's the exclusionary rule under the rules of evidence.
Well, all of the reports were accepted through okay, all of the reports, the psychological evaluation, the neuropsychological evaluation, and other and there's other documents too, and they were accepted through the judge's
Court hearing.
yeah, court hearing, and under advisement, I guess. The judge took all that stuff, looked at it, and he didn't. I mean, at that time, I did not know if he was for us or if he was for DFS. But after he made his decision, it took like at least about 3 months for him to decide to terminate my rights. But he read everything, and I was thinking, okay, how can you read everything and you are saying certain things that are not true, and they are true in the reports, and it didn't really make any sense to me, because I still think I mean, I'm 31 years old. And my son's almost about 5 years old. And I have and I have never ever abused them and nothing like that. And I was thinking, they stole my son without oh yeah, without due process, without warrant, and it just they just took him because because one thing is they want money. Second of all, they assume that they judge and assume me because of my disabilities. Even though I have disabilities, that still doesn't make me not a good parent for Michael. So, but the judge did. The judge just checked CPS's side and not our side. Totally.
And that's what they do, because they're out to make money, and almost all of our states are bankrupt, and the only way they can continue operating is by selling our children. And this is what has been happening.
I would make the argument in federal court, as well as any other court proceeding that you go to, is that the rules and evidence, if they were adhered to, that this wouldn't have led to the proceedings taking place the way they did to remove your child. If they were followed, it would have prevented that from happening. And the judge doesn't listen to it. The judge doesn't want to hear it because they want to.
No, that's not true.
That's what he's saying.
Oh, no, that's what he's saying. And
okay.
And so,
Yeah,
I think the big thing here is that you got to know what the rules of court procedure are, right?
Right, I understand that. Yes.
Okay, the other thing too is, again, this whole thing was set off by Children's Mercy Hospital.
Exactly.
And the Children's Mercy Hospital made 2 hotline calls to DFS, and they were working in collusion with each other starting August the 30th, August the 20th, and they kept talking back and forth on how they could get Michael away from Kelly. And they actually tried to prove that Kelly was incapable of taking care of Michael by having her have 72 hours of just her totally taking care of Michael. No help from any nurses. Everything she was to do on her own.
At the hospital.
And they were critical of, even to the point of, well, she spilled some formula. And then they kept accusing her, and one nurse threatened her that if she couldn't do this, that they would have to hotline her. And so basically they somehow or some way, this was a setup.
Yeah, it was a setup.
Between Children's Mercy Hospital and Division of Family Services. And I have a document to prove that.
I have a question. So how was your child before the hospital and Child Protective Services got involved? I mean, were you able to take care of your child?
Yes, I was.
And how was the child
I only had him for 2 months, from August to October 3rd.
Okay.
I mean, how was his health during that time?
Okay, he was.
Okay, his health was. Okay, Michael was not in good health. He was having trouble gaining weight. He was having trouble acid reflux. He was having trouble keeping the formula down. So he kept on spitting up the formula and everything.
But his food was not turning into nutrition.
Exactly.
The problem, because the doctor kept saying he's well nourished, he's well hydrated, but he has
failure to thrive.
But he said that he felt that the failure to thrive came on about a week after he was born.
Right.
So it wasn't because of anything that you did. It was with this.
No, and as I said, they did not bring out the pediatrician's report at all. They just said that Kelly was negligent. She didn't feed him enough, and that's another thing.
Did they have access to the report?
Yes, I do.
And they ignored it? They ignored it?
Access
yes,
to the
they
report?
did.
Yeah.
Yeah, well, that's important evidence right there. That's another thing that I would take with the independent psychological eval. I would even take it to them, before you get there, because I mean, them seeing that document too, and then, doing the independent psychological eval may help, because they may be able to say, well, we have this other thing that says, it wasn't because of anything that she did. The child was having deficiencies, from birth.
Actually, I'm suspecting that it possibly could be because of a shot, because there were 2 shots given in that time period. I don't know that for sure.
Well, do you have the report of the material of the contents of the shot that they gave the child?
Yeah, we do.
We have what the shots were,
Yeah,
and
we do. Yeah.
Okay, research.
I would look up that and see if there's any reviews as to deficiencies when it comes to that type of administration of that type of,
Okay, they are also saying that he has microcephaly, which I don't think so, but
microcephaly is it's like
the brain is smaller and the head is smaller, and Michael's head is not smaller. But then they hold that against Kelly. And when they took him to have this to get DNA genetic testing, Kelly was not present. She told them that the foster parent told them that Kelly was mentally delayed. And so she was not able to give any information to them about the true history. Then they said that then the foster mother was given time with the hospital on helping her understand what this was all about. They never explained it to Kelly. So
They never included Kelly in the medical treatment of the child.
No,
No.
they did not. No.
So that's a violation of those rights as well as a parent. Medical rights.
It took us 6 months to get a year's report of his medical history from Children's Mercy Hospital through the attorney, because Elisa, who is the caseworker, just never sent him. And then as it was, by the time we got him, we were a year behind even after that, and what his medical history is. And he has tons of paper from Children's Mercy Hospital of all the things that he had, of the testing they did. I mean, there's maybe at least 500 papers of it.
How is the child now? I mean, or the last time that you've seen the child, I mean, how is the child?
I saw him on May 9th.
A year ago in May 28th.
And how many months had the child? What was the child's age at that point?
4. 4.
Okay, 4 years old?
Yes.
And how is the child? How is the child's health? I mean, when did it improve that the deficiencies, when did they improve?
He's
still not improving. It's
no.
he's
improving somewhat.
Somewhat, but not.
He has language delays.
He has language delays like me.
He's been about 6 months behind in progress of the health progress.
Yeah, the growth. Yeah.
And then just the health process. He was delayed.
Well, that's even more evidence to conclude that the child was born with this, and that it's not Kelly.
I don't know if he was born with it, or
it's just like getting cancer. You don't get cancer when you're born, like you get cancer after. It's like sometimes you get born with it. I mean, but it's not that anyone was responsible for someone getting cancer. I mean,
the one thing too is that in January of 2015,
it's a medical problem. It's not.
The doctor at that time said that he was very concerned about Michael having failure to thrive. That he was still having problems, which they say Kelly caused 2 years after he was taken.
Yeah.
They keep repeating Kelly as just being that her problem.
And Fernando's
you can't be held
right.
responsible.
Yeah.
You can't be held responsible for the care of the child, for anything that's happening to the child while the child's in the state care.
No.
They can't use that against you.
Well, what I meant was by that is that what they're saying is that Kelly started it. Kelly didn't take care of him, so he's negligent. But yet then he had the same symptoms 2 years into being in state care, and he did not, there was nothing different, nothing special done. There wasn't any, Kelly had nothing to do with that part.
Right.
Well, as long as the child's under the state care, you're not responsible for any of the medical health of the child. It can't be put on you to say that you're the one that's responsible for that happening.
Well, they do anyway.
Well,
I mean,
that's
where they're wrong.
That's where they're
That's
wrong.
where it's not going to help.
The last time I saw the caseworker, she told me that I was making him die, and I was saying, what, and I said, no, I'm not. I said I was trying to do my best, and you're telling me that I'm making my son die.
Who said that?
That's a horrible thing.
The
to
caseworker.
say.
Okay, and was there a medical professional to substantiate that in court?
No,
that's the whole point. That's the whole point I'm making, is that there was never any medical professional in court. It could never have been used as a medical diagnosis in court.
I know, but she said it in court that I was making him die. I was saying I'm not making him die. I was trying to do the best I can. Good.
So what this what this sounds like is that this is what has happened, and you know, it's wrong, completely wrong, and you have evidence that will mitigate what their statements.
It would exonerate. It would exonerate
Totally.
you. You have
Yeah.
evidence that it would exonerate you. It's called exculpatory evidence. You have existing exculpatory evidence that's critical to the legal proceeding that, if presented, would exonerate you.
That was one of the decisions that the judge made. Is one of his decisions that he made the judgment on termination. Is he accused Kelly of not being willing to accept that she caused Michael's problems.
Right.
Well, the social worker, when the social worker speaks on behalf of a medical report or diagnosis, the medical professional either has to be there to substantiate the claims that the social worker is making, or if the social worker is just making them and there's no medical professional there and she's only pointing at the material, that material cannot be used to, deprive you of certain rights or, to take the child. And it was used in your case to do that. And that's the thing. If they were upheld to the rules of evidence, if they listened to the exculpatory evidence, it would have exonerated you. You would have been in the place you're in, and you would have had your child returned back to you, and there would be a legal proceeding unsubstantiated. But instead, they did what they did, and they did it under color state law to, use the juvenile dependency process to remove your constitutional rights or deprive you or violate them, and not recognize certain critical evidence that, if heard, would have made the case, go sour, and you would have gotten your child back.
He
And
heard all the evidence.
I think that there are a lot of parents out there that who have existing exculpatory evidence that was, like in my case, there was documents provided and information provided that totally contradicted what CPS was saying, and the judge would deny that evidence into
It's
court record.
concealed or withheld sometimes as well.
Mm-hmm. And so this is really good information for a lot of parents out there, and I really appreciate, Fernando, you taking the time out this evening to help Kelly and Marge out in understanding what they can do next. I would like to talk a little bit about some other projects that we've been working on here in the Parent Advocate Network and the Coalition for Protection of Children and Families. On July 13th, I believe it was, I put out the poll, which helped to bring in a lot of people, advocates and parents alike. And this is about getting delegations set up in every state so that parents and advocates and parent advocates, because we all need to be advocating for each other here, can support each other. And, like right here on the list that I'm showing in Missouri, there's already 5 people. So Kelly, I hope that you can get in contact with the 3 other people in your state. Or 3 or 4, actually there are 6 there. I apologize, number counting. So this is about helping everybody out, everybody being able to connect and have closer connections within your state of other parents that are experiencing some of the issues you've been experiencing in your state, and then also being able to support each other in this venture. It's something that is really near and dear to my heart, to help people in my area to know their rights and to be able to fight for their family to be together. And I hope that we can get more people connected by having this poll. It's been shared 155 times or more, and some people are having a little difficulty clicking on their state. And my suggestion is that those who are unable to have their name clicked on that state, they refresh their browser menu and restart the computer And that is just because there are cookies that keep on going on people's computers that can stop certain apps from working properly. But if all else fails, on our page at the Coalition for Protection of Children and Families on Facebook, we have state by state, county by county reform projects, and every state flag is on this, in this photo album, and you can click on any of these photos and it will come up with information about how to about knowing your rights in the state of Oklahoma, for example. This was just one I clicked on. And then there's also information, contact information to contact your county DA office, which is what we've been working to help parents do. The more people that talk to their county DAs about the civil rights violations by their department in each county, that
Also, the board of supervisors in every county should be gone too.
Okay, the board of, okay, that sounds good. I'll have to work on that too. I mean, I sent a complaint, a damages claim to my county board of supervisors, and so that's another.
Well, they can go, parents can go protest like in person on the record. It's public record. They can speak into the microphone, get designated time to speak and a select amount of time. Anyone can do that, and they can speak about anything that's going on in their county that should be stopped.
And what we want is for parents and advocates to be joining together. It's been difficult to get parents and advocates out to protest, and I think part of that has to do with it's hard to get connected with other parents in this battle because it's so heartbreaking when parents lose their children and they know that their children are alive and they're being told they can't see them and they can't send them gifts, they can't talk to them on the phone, and it's hard for a lot of parents to pull themselves out of that depression and start taking action. But that's what we need to do. We need to start taking action and doing it as a community and working in everybody working in their state. Like we have protests in Sacramento. I went to several I went to one in March and one it was one in May and one in April. The one in April was the vigil for Nancy Schaefer that I helped put together. And, you know, we just have to look. There's all kinds of events going on at your state capitals, and you can also create an event in your county or town and start speaking out. Nothing's going to change if we don't start getting active and working together in our towns and in our counties and in our states and nationally. And so that poll I created is for everybody to use to connect and join in, and let's do this together. We can. I know we can make it happen. Yes, Kelly.
Oh, my mom has a question.
Okay, my question is, I'm thinking from just reading what different people are saying that some of these people are so overwhelmed by what has happened to them, they have no idea where to go. So I was just wondering what ideas could come up with how to direct them to advocating, because I don't think they know, majority don't know where to start because they're still taken by the fact that they've been used by the state and by the government. And I really think we need to provide some direction, even if we just do an outline form of steps that you might do to become active, or sites you might go to.
And this photo album that has been created is a good place for parents who are connecting to advertise events like in Arizona or Arkansas or California or Colorado, to put a post link to that And you know, we talk about a lot of different events going on in the Facebook group at the Coalition for Protection of Children and Families. And I know that there are a lot of other groups that are out there that post events. We need to start working on organizing and making them all come into one location where everybody can see all of the events in their area. And that brings me to the next topic that I did want to mention regarding volunteers. The Coalition for Protection of Children and Family is seeking volunteers. There are multiple positions available, which I have posted on our page, and it's been created as a poll. So, so far there's been a few responses to this new poll. We're looking for secretary, treasurer, event coordinator, and I'm looking for the rest of them right now because I can't remember all of them.
Okay, on that, is it possible to give a little bit of saying about on each one of some of the duties this person would have, so they know what they're expected to do, and they know if, that way they know if they're qualified for it?
Well,
You understand what
yes, I understand what you're saying, and what I would say is that at this point in time, it's possible, but there's only so many characters that you can put in each of the options. I think it's 140 characters, so it limits exactly how to explain or to explain it. So where did it go? I had it. I was going to share it here. Now I can't find it.
Yeah.
So now the floor is open until I can find this poll. If anybody has any questions or comments.
Yeah, Fernando, I have a question for you. I am an advocate in the Los Angeles County, and we've changed our focus a little bit because it's just exactly like Kelly and Marge. They're in Missouri, and so for me to be there every day, to go down to this county and talk to the agencies and work as their advocate in Missouri just isn't realistic. So part of that focus now is it possible for you to send me an email with your contact information, because I'm just getting my feet wet and uh, discovering the pathway to accomplish what you have already accomplished, which is getting families reunited. And I promise I won't be a nuisance, but when I hit those critical hurdles, that I may shoot you an email and get your advice, basically.
Yeah, I can do that.
Okay, that's my right on the screen is my email address.
Here,
Spreadlight@yahoo.com.
Okay.
And I'm also working on getting on the website, on our page about us. I want to get advocates' names and information. We're putting together a detailed list to assist parents in getting connected. And this next thing that I'm sharing is actually that other poll that I created, looking for volunteers. So I understand about making a little bit more of a comment about what some of these positions are. But I mean, emergency aid for families in each state, that's definitely a very important piece that I hear all the time parents who can't get to their visits because gas money is gone, parents who aren't able to pick up their children when they're being told by the FBI or some department agency that they need to come pick up their kids, and they don't have a crib for their baby or some, those kind of situations. And we want to be able to provide some emergency aid for these families in order that they better transition into reunification with their children. And then there's some other positions here as well, secretary and treasurer and the like. So, and everybody's welcome to add as well.
I just wanted, Fernando, that your email address popped in there for a brief moment, but it wasn't long enough for me to get all the information. So if you could send me an email with your contact information on it at my email address, then it'll be there, and I can open it up and put it in contact. Okay.
Okay.
Thank you. Kelly, you guys are really the one of the worst case scenarios that really I was excited from the standpoint of if we can go through the process of getting you reunited with your child, that's going to be a real casework for the whole organization. And it's my understanding that there are advocates in Missouri that are willing to help you in your state that Lyra had mentioned to me, and it's important that you try to reach out and get in contact with those people.
Veronica Ferguson is not in the state of Missouri.
I understand, but I asked her to be one of my advocates. I know she's in New Jersey. I know that, but she said she's willing to be my advocate too.
Yeah, that's great. So just keep those contact avenues open. Keep trying to connect and communicate with her. And then again, on that poll, the state by state poll that I shared, you guys also have the ability to access the parent advocates in Missouri and in states surrounding your area if you wish to. That's part of why that poll has been created.
Okay, I understand. Dale, why did you tell or say that my case was one of the worst case scenarios?
When I say that, Kelly, when I say worst, it's the most egregious example of somebody's human rights and constitutional rights being violated. Okay.
Oh, okay.
That's what I mean. It's a worst case of a constitutional right violation that I know of personally, as you as people, Okay. And so if we can demonstrate success in you getting reunited with your child, that's going to be a huge standpoint of all the information that was required, the steps that were taken, the process that we went through. So it's important that we work together in helping you, because the reason why I'm here is I want to prove to myself that this organization that I'm part of is capable of reuniting families. Okay.
Well, it is, Dale. It is, and we are, and that's the beautiful thing about this.
And so my skill set is not up to speed yet. Okay, my desire and my passion to get these families reunited is there, but the skills that Fernando has acquired to make it possible for families get back together. So I've got some.
But how?
I've got some.
The question is how.
I've got some work to do. Okay.
And this is what we've been talking about this meeting, is how to get your children back, how to keep on going through the process, exhausting all of your options on the state level, filing that complaint with your state board of directors, filing the complaints with the Judicial Accountability or Judicial Review Board, and even filing a complaint with your county grand jury, I believe. Yeah, that's what I did. I sent a complaint to them as well.
I guess some of what both Kelly and I would need is somebody to just specifically tell us the steps for each area, because it gets confusing.
I can do that.
Okay, I'd appreciate it, because the
Just
other
give
thing is
me-
I was wondering is the fraud upon the court.
Well,
I mean,
and
I
we
believe
also,
that happened in our case.
and we also need to be able to put this in a list so that all parent advocates have the ability to go step by step on this. And Fernando, I'm yeah.
Kelly, is that your is that your grandma?
I know, that's my mom, Margaret.
Your mom. Okay.
Yeah.
So pretty much what your mom was saying, it went out the window, my thought. Sorry. It was pretty important too. It was really important. And it was something that had to say something about what you were saying. So it just went in one ear and went out the other, sorry.
That happens to all of us, so I can totally understand that one. But yeah, it's great. We're getting more and more parents.
Oh, I remember.
Information.
I remember.
So go for it.
Okay, so you said fraud upon the court issue, right? You
Right.
believe that was in your case. Well, the thing is, it's not about the fraud upon the court. It's more about the material matters that exist that were misrepresented. They misrepresent all of the material fact in your case, so that way they can do what they do. And instead of it being fraud, it's more like the deception and the misrepresentation of the material.
Right, but I guess we need help in putting that together, because there's a lot of things that happen, but I'm not sure which ones to point out.
There was fraud. It's just the level of fraud was the deception and the misrepresentation of the evidence.
Right. Okay. And then
Did I get that right then in the notes? Or can you see that, Fernando?
No, it didn't pop up this time, but I'll look.
Okay.
Yeah, it says what it says is fraud upon the court. Material matters that exist that were misrepresented and misrepresentation of the material too.
Okay,
So,
what about the fact that the caseworker constantly 5 different times refused to do what the judge ordered her to do, and then she turns around and blames Kelly for it?
I would point that out. I would definitely point out that I would definitely point out exactly what you just said right now.
Okay,
and put that in the actual federal
and then
complaint.
they had
she caused because she wouldn't follow the court order. She caused Kelly to only see Michael 29 hours in the year of 2015. And she was supposed to order to see them 40 hours a month by the judge.
And the caseworker just didn't do it.
Huh?
And the caseworker just totally ignored it or just disobeyed.
No, she didn't do it because Kelly had a problem of anger with me, and she hit me, and then she's got that taken care of. She's gotten help from the court, but the caseworker wouldn't drop it. She kept saying that Kelly was a danger to Michael. Kelly never did anything to Michael. She got anger management. She graduated from the anger management court with
was
high
amazing.
honors. She did it faster than any other person
6
has
out of 12
completed it, and the
months.
judge complimented her too.
I completed that 6 out of 12 months. A lot of people had to do, or the majority of people would do 12 months to, actually 12 months to 2 years. I did 6 out of 12 months. So it's not
Okay, well,
because I had.
I would point out that it's a really sensitive issue, that topic that you brought up. I would, refrain from bringing those about in a court. But what I would do is that make the distinction that nothing was ever done to the child, and that, even though that there may have been some anger issue, that was not directed towards the child. There was never any situation that happened because of Kelly and a child. So when it comes to that situation, it's as if it's not really relevant. And so that's why I said it's really very sensitive, because when you bring that to light, it can then be, all the questions can be arisen, and it can hurt the case.
It was brought to light a long time ago, from the very beginning, from when it happened, and they were constantly.
That's the lower court. But in the new matters that are brought forth, so say like you go forth in the federal court or the appellate court, I would definitely refrain from the actual event, but make the distinction that there was never anything done to the child. Kelly never would have done anything to a child, and there was not a situation that involved a child, so it wouldn't have needed treatment. That she may have had an issue, but that's not for CPS, to decide whether or not she has these. That would be more for a therapist to decide,
Well, that's that's one of the decisions used by the judge, is that she did not complete anger management.
But she did, right?
I showed
She
them.
did,
I did.
and they testified in court. In fact, the person who was in charge of Kelly's anger management, she testified for Kelly.
Yeah, she did.
That issue, I would definitely also bring that issue up, because, you did do the service and you did receive the treatment. You should have been allowed to be better, to have gotten better because of that program.
I do. I have, and I have.
They didn't allow you to get better because they didn't even take that into account. You know what I mean? They didn't take your going through classes as remedying that situation.
They don't really want me to get better.
No, they didn't.
Really.
So it's almost like they tried to make you out to be as worst as it could be by violating all your rights possible.
Even though I was trying my very hardest to prove every single thing, like I proved myself from about 3 years ago. Yeah, I proved on that. I proved, and plus I changed my life around too. Plus I showed the judge that I got the certificate from the anger management too.
And what did the judge do when you brought that certificate up?
Nothing. He just, I don't know if he looked at it or what, but he didn't say.
Did they ask for it after you said something about it, or?
Well, your lawyer represented it, didn't she?
My lawyer represented it, and she handed it over to the judge.
Lyra?
To the judge, and I don't think
your anger management.
Did they hand it back to the attorney?
I had an anger management book that I did.
Just the certificate. Where did the certificate go after it went into possession of the judge's hands?
I think he took all of the. I think he took all of the. Hold on, just a minute. I'm getting. Okay.
Take a deep breath now.
That's what I just did. Okay.
I want to know what happened to the certificate because it's important to know whether or not the judge kept it. If the judge kept it, then it went into the record.
No, it's whether he has a copy.
He has a copy of it, but I really don't know what I'm not sure what he did with it. Except,
okay, he ignored it if he had it because he said that Kelly did not take care of her anger management and that therefore she was not reliable.
And plus, I did show him the anger management book that I was doing too, because it showed showed what I did in the book, and plus the certificate too. That is proof right there too. And
as long as the judge got the certificate, as long as the judge held the certificate in court, that was enough for the evidence to be put into that file. And as long as there was a copy, it went into the file. That file can be looked at by anyone in that county that was a party to the case or any government officials. And it still exists in that record as long as the attorney represented it and as long as the attorney handed it to the judge. Just because a material doesn't get looked at or heard or acknowledged completely, as long as it was represented, it's on the record. It's in the microphone, on the transcripts, the judge saying one thing, the attorney saying another, the court reporter, stenographer is typing it all. Every response in that courtroom is typed.
Right, I understand that, but the judge didn't really do anything
It's
about
evidence.
it. I understand it's evidence.
He said there was no evidence.
There was
Well, the record and transcript is evidence in a different proceeding. So say you go get the transcripts, you get all the documents, you can use that in other court proceedings.
Okay, she needs an explanation. She's confused.
I'm confused. I got confused after you said, okay, there's no evidence. I don't know I'm not sure what I'm not, that right there, I got confused because I don't really know what you were talking about after there was no evidence.
No, I mean, there is evidence. It's like the transcript.
Oh, okay, there is
the transcript is evidence. Anything that you say on the record in that microphone, that's a response. That's typed by the stenographer. That is evidence.
Okay.
And can be used in other court proceedings.
Okay, I get it now. Okay. So,
how can you find out about the background of a judge?
They have an autobiography. You just go to the California court website, or not California, I mean your state.
Missouri.
Missouri.
Yeah. And that would be court. It would be the court dot and then whatever the state's abbreviation is, and then pretty much it'll pull up that material. And you should be able to find the judges' names, everything about the judge.
I found it. I found them a couple, not a couple days ago, but like a couple times. And this judge that we had in family court, he's a minister, and plus a judge. And I'm not sure what else.
Plus a judge in family court.
Yeah, plus a judge in family court.
He's judging 16th Judicial.
Right. But I'm not sure. Okay, the only reason why I'm puzzled about him because I was thinking, okay, how can you be a judge and you're on the stand too, him, and the judge is on the stand actually behind the stand. How can you be a judge and be a minister? And you're not, and the judge is not going by the laws. That's wrong right there. How can someone do that? It's like, I don't get it. Well, not this one. I really don't get it. It's like,
as long as he's acting as the judge, he has the interest of taking into anything the state wants to do against you into account. And that's what's happening is it's totally biased. It leads to proceedings that, for deprived rights. that's done this way, because if they don't do it that way, they don't get paid.
I understand, but the judge, I mean, he's a minister, and I was thinking, how can you be a minister and a judge, and I mean, a minister is you preach to people and everything. I know that, and plus
How
I
can
know
you live with yourself doing all those things? I understand that, like.
But how can a judge be honest and be truthful about everything that he does on being the minister plus the judge too? I think do that. And it's like the judge. I think I think the judge didn't listen to our case. It just like went in one ear and then out the other. It's like, okay. We had proof about everything about that Michael was stolen and everything, and the judge didn't really listen. It's like, okay, I don't get it. I don't get him. It's like,
Kelly,
They have
I
all
understand.
the other judges. They're all in cahoots together. They all go to meetings together. The attorneys that are in that process, they all go, to lunch together. They all see each other every day. And the thing is, as long as that system's in there like that, and they don't get paid unless they do these things the way that they're supposed to do it, if they don't do it that way, how is it that they're going to keep their job? How is it that the other judges are going to look at them and say, well, you're the responsible person for not, you're a liability now because now we're not getting paid. So that's the thing is, no judge is going to want that title in their profession when all the other judges have to obey by what the state is trying to do.
right, okay.
And I understand that this is very frustrating and hard for you to
Well,
express.
it's not totally. I'm just puzzled about the judge. I'm like, okay, if I was a judge and plus if I was a minister, I would honestly be honest with myself and be honest with and being a judge too. And this judge is not honest. That's why I don't understand.
They're all lawyers. At one point, in order to be a judge, you have to be a lawyer. The definition of lawyer is liar.
Lawyer liar.
I had back in the 60s, I was in a corporate attorney's office, and he was a friend of my uncle, and he was the godfather of President Kennedy. And he told me when I was 17, he looked right at me, his glasses were way down on his nose, and he looked right at me. He said, "Son, there's not an honest judge in the state of Illinois. Okay, every one of them has a price, and that's just the legal system. It's as flawed as human beings are.
Even more possibly.
Yeah.
Capitalism.
They are all human beings too. So.
Exactly. And
so in spite of this, we got the Constitution and we have our rights, and they aren't granted to us, so we have to fight for them.
Yeah, it's almost like a dictatorship.
Yeah.
We have to know what they are too.
That's right.
And so it's complicated, Marge, and we're least down here on the bottom. We're least equipped to defend ourselves, and they know that, so we can be easily taken advantage of.
Well, there's a lot of people who don't know anything about the Constitution right now, so they have to be taught.
And they don't know how many of the constitutional rights are being erased very quickly here right now. So.
Well, when the president is sitting up there and he's doing everything he can to like a dust broom, get the Constitution out of the way so they can just pull the whims out of the rear end. It's just startling.
I think there are some good things and bad things about the president, and I try not to bring that discussion here. But I believe that we can get the president to support the family rights movement and support reestablishing the order that is supposed to be of the family being first, having first foremost rights over their children. And I do believe that we can do that with this president. And so I
Did you?
keep on encouraging
Okay,
people to sign our petition, because we see the ACL no 80, is it ACLU? No. Yeah, ACLU, ADA, and DOJ. Okay, so how they're standing up for the families on the border, the illegal immigrants that have been separated, and the children that have been laundered to some place or another, and they don't even now know where a lot of these children came from, who their parents are, and where they're going, which is truly tragic. And I don't have any
I have a couple
malintent.
things to say on that topic.
Okay, go for it. But
Okay, so the ABA, the
yeah.
American Bar Association, they came out with a 3-page writing that the president of the ABA signed, and it talks about the case law in federal cases when it comes to ICE removing the children from their families, and that executive order that comes about that's supposed to keep those families from getting removed. I mean, those children from getting removed from their families and their parents, and it's supposed to keep them together. Well, they came out with this document, and it actually talks about Troxel versus Granville, that same case that I talk about all the time, as a fundamental right to the custody, care, and control of your children as long as there's a fit parent available. And that same case was cited, saying that not only was it unconstitutional for the federal government and federal officials to use enforcement processes to affect those deprivations of those constitutional rights and protections, when there's over 80 years of case precedent in regards to that case in the federal courts, that any time it comes with the process of the state officials implementing enforcement of child welfare, or whether that be federal officials implementing the enforcement against, on the federal side by federal officials implementing that procedure to perfect the deprivation rights of those constitutional rights, instead of keeping the families together, removing them, and doing that was a unconstitutional act. And that document is 3 pages, and it talks about that. It's even more reasons why American families, that document shows both for the immigrants and for the American families as to why it was unconstitutional, what CPS is doing and what the feds are doing. I mean, then there's also 2 executive orders that the president signed. One's supposed to go after fraud, and it lists Health and Human Services in that. It also, the other one is to keep the families together, and that doesn't go for just immigrants. It goes for both American families and immigrants. Then there's the human rights abuses on the executive order that's supposed to use the Treasury Department to sanction anyone that commits human rights abuses or uses legal proceedings or criminal or civil, juvenile, it doesn't matter, family court. That executive order is supposed to put sanctions by the Treasury Department against those entities for doing human rights abuses and violations.
Do you have
Okay, Deb, you
links that you can share of those executive orders, or do you know where people can find those executive orders and review them?
Yeah, the one is the executive order for separation of families to keep them together. Then there's the one on fraud that's supposed to sanction any entity that commits fraud. Then there is the executive order that's supposed to be to prevent human rights abuses. Any entity that does human rights abuses will be sanctioned by the Treasury Department. Anything like that can be searched in Google search. It would come up real easy.
Well,
Okay.
I was going to say the best example of all of this is the federal judge that came back and threw she basically is forcing the federal government to bring these immigrant families back together and
Yep.
setting deadlines, so it has teeth,
Okay, I was wondering, have you all did you see Mark Ludwig's video about Title IV?
Mark,
He makes a
what?
lot of videos,
Yeah, he does.
What?
but I haven't seen that one.
Okay, he said that he accomplished a lot, that he met with 4 areas of government, and all 4 of them said they would work toward changing Title IV, and he wants people he's suggesting that the people across the nation organize their events in such a way that they all kind of replicate each other, and therefore it shows a united front. And then he wants people to contact their government representatives to let them know that they want this to happen about Title IV and how it might be affecting their families.
And what's the question?
Okay, basically, I just wanted to know if you had seen that video, and if you haven't, maybe you
I haven't.
might look at it and see what you think about it.
It sounds like a great thing. Everything that Mark Lingwood's doing is a great thing. His shared parenting movement is a great thing. That movement that you're talking about, I haven't heard his video, but I mean, he's doing great things. I mean, Title IV needs to be looked at, needs to be evaluated. It needs to go away. It needs to be changed. It needs to be repealed and replaced. Something needs to be done with Title IV because it doesn't only do the Title D, it does Title E, creating these problems for the parents and for the children. It's causing the federal government to give incentive to give money to the states to do this. I mean,
The White House, and there was one, I think Human Development, no, what is that, the one that covers CPS?
Department of Health and Human Services.
Right. That he met with all 4 of them, and all 4 of them were very interested in doing something about it. And then he's supposed to have had another conversation with them this week with another man, and they were going to discuss more as to what should be done. But he said this is the first time that they've had all 4 people, all 4 groups ready to go and to change the Title IV.
it sounds like a great thing. I hope he's successful.
But he's just asking people to, let other people know, to pass it around as much as possible. He's also asking for financial help in supporting this cause because of the amount of, like, the travel time to Washington D.C. and all that. And then he was very very, very happy, and very he was proud of the success. But he said he didn't want any one group to take it. He didn't want himself or any one group to be recognized as special, because he said we're all in this together and we all work together.
That's right, we are. And when we work together, we'll get the job done. And again, I bring up the poll is on the Coalition for Protection of Children and Families Facebook page and our group, and we're getting more and more people adding their names and it's going to help us organize. And yeah, I believe that we should have events all connected across the country to be in coincide with each other for greater impact. It does require that every state, the parents and families and advocates join together and are able to connect with each other, and that's part of what the poll has been created to do. I hope that parents and advocates will add their name to this poll. I have asked that any parents and advocates who do add their name use the box that is next to the state name, so that we know, because this has been shared 155 times, and it's hard to keep track when people put their name on the list or the post instead of clicking the box for their state. And so that, and if all else fails, you can also follow the link available here in the description section for the photo album with the state flags. And this is going to help everybody, you know, with all of our projects, with all the parts, because this is a multi-headed monster that we are dealing with. And so we need to have multiple angles of attack at the same time. And it's got to be orchestrated in simple terms, but effective terms. And I think there is going to be great progress with what we're doing here, and that everybody is joining in and adding their contribution, their part, because it's not just one person, it's all of us. It takes all of us as a united force to turn the tide of this gross human rights violations and civil rights violations that we have all experienced and are experiencing. And I am grateful that all of you have joined tonight. And, you know, this is great. We can share this information with other parents when it is published on the site and on the Facebook page and on the YouTube channel, and just keep moving forward. And I would like to talk with you, Fernando, at some point in the future, you and Veronica and a couple of other people, so that we can see about putting something together that parents can learn through a tutorial how to advocate for each other with, you know, all of the information at hand. So
Okay, yeah, that would be great.
Yeah. I thank you, Fernando. Thank you. I really appreciate all the information that you've helped us put together here. And as things develop, and I have, you know, I have some I've got some issues that are focused and in the works that you can advise me, but I'm not there yet.
Well, I would definitely look at the California rules of evidence and look at the hearsay rule and look at the exclusionary rule of evidence. It's no different. The California law is a little bit different, but I mean, it's pretty much the same when it comes to federal rules of civil procedure or criminal procedure and the rules of evidence in the federal courts as well. It's pretty much
I've got that on my list. Rules of evidence and procedure, exculpatory, and
exclusionary rule is important to have on there as well.
Yeah.
Fernando and Dale and Lyra, I just want to say thank you very much for your help, your great support.
You know,
always. You guys, Marge, feel free to call me anytime. Okay, if I can nudge the process along, I want to. It's just we're at a bit of a disadvantage, but then all we can do is stick together and work together to make this thing work.
Okay.
Yeah.
amen to that. Amen to that. We can do it. Thank you all for joining us tonight. If you have found some benefit from watching and participating in the Parent Advocate Network and would like to support us, please visit www.coalitionforprotection.com and click to donate by PayPal. We thank you for your support, and you all have a great evening.
Good night, everybody.
Same to you.
Good night.
God
Good night.
bless.
Good night. Good night.